Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of civil procedure, criminal procedure and legal profession. To know more about them, please watch the video fully. Hi friends, in the important judgment titled X versus Registrar General, High Court of Madhya Pradesh and another, pronounced on 10th February 2022, the Supreme Court has held that a transfer order is unsustainable if it is based on an irrelevant ground and not on any factor germane for pausing it. The facts of the case would be that the petitioner was selected in the competitive examination of Madhya Pradesh Higher Judicial Services at district entry level, direct recruitment from bar conducted in the year 2011 and stood second in the said examination. On the selection, the petitioner was posted as second to first additional district and session judge. Petitioner was given C good grading in the first annual confidential report and she was graded B very good in the second annual confidential report. Petitioner alleged that thereafter she was sexually harassed by the administrative justice, and due to said sexual harassment and at the instance of administrative justice, the then district and session judge addressed a complaint against her to the MP High Court. She also alleged that she was faced with transfer from category A city to category C city and also an Naxal affected area in violation of the extant transfer policy of the High Court. She further alleged that since the transfer would have prevented her from being with her daughter, who was then appearing for the board exams, she was faced with no option but to resign. A judge's inquiry committee opined that the petitioner should be reinstated in service as the transfer of the petitioner was irregular. Pursuant to recommendation of the judge's inquiry committee, the petitioner addressed a representation to the then Chief Justice of MP High Court for her reinstatement in service. The MP High Court communicated the rejection of the petitioner's representation by a full court in its meeting. The petitioner thereafter filed the present petition. The counsel for the petitioner clarified that the petitioner is not pressing the present matter on the ground of sexual harassment by the administrative justice, but is limiting her submissions with regard to the transfer order being illegal and mala fide and the consequent resignation amounting to constructive dismissal. The issues posed for consideration are whether the order transferring the petitioner from Gwalior to Sree is legal, whether the orders of MP High Court rejecting the petitioner's representations were legal, and whether the resignation of the petitioner can be considered to be voluntary or one which was forced due to circumstances. The Supreme Court has held that the transfer policy incorporated by the MP High Court has provided in detail the procedure that is required to be followed with regard to effecting the transfer of the judicial officers, their tenure at a particular posting, the circumstances in which the case should be considered for permitting the judicial officers to stay beyond the prescribed period, and the manner in which the representation is to be considered. The said transfer policy is only a set of guidelines for internal administration of the district judiciary issued by the MP High Court. However, while exercising its functions on the administrative side, the MP High Court would also be a state within the meaning of Article 12 of the Constitution of India. Though the transfer policy may not be enforceable in law, but when the transfer policy has been framed by the MP High Court for administration of the district judiciary, every judicial officer will have a legitimate expectation that such a policy should be given due weightage when the cases of judicial officers for transfer are being considered. Facts on record show that neither the procedure as prescribed under Class 9 of the transfer policy of obtaining the comments from the district judge and the portfolio judge were complied with, nor the transfer committee consider the provisions of Class 9A of the transfer policy. When subclass A of the Class 9 of the transfer policy provided that the case of a judicial officer for an extension should be considered if such judicial officer's daughter, not son, was to appear for the final year of board examination or university examination, and when such educational institution where such daughter is studying does not have hostel facility for girls, the petitioner had a legitimate expectation that the MP High Court would consider her request in accordance therewith. From the perusal of the transfer policy, it is clear that total 3 weeks period is provided between the date of the receipt of the representation and the decision thereon. However, in the present case, within 2 days from the submission of the representation, the transfer committee rejected the same without considering subclass A of class 9 of the transfer policy. The petitioner had a legitimate expectation in view of class 10 of the transfer policy to have her case considered for posting at any of the 4 places in the event her request for retention at the then present posting was not considered, and as such she made the second representation. This court is at pains to say that the rejection of the second representation depicts total non-application of mind by the then Registrar General as well as the then Judge of the Transfer Committee of the MP High Court. The proposal of the then Registrar General was made in a casual manner and accepted by the then Judge on the Transfer Committee in a mechanical manner. As per the transfer policy, a judicial officer is required to be transferred from category A city to category B city, from B to C, from C to D, and from D to A. However, in the case of the petitioner was directly transferred from Gwalior, which is category A city, to Sindhi, which is category C city. The 4 cities which have been mentioned by the petitioner in her second representation are B category cities. Coupled with the admission that the transfer of the petitioner was effected on the basis of the complaint made by the then District and Session Judge Gwalior, it is difficult to accept the contention on behalf of the MP High Court that the transfer of the petitioner was made in the public interest or in the interest of the administration. The petitioner has established that her transfer order was in contravention of the transfer policy and that the rejection of her 2 representations, in addition of being contrary to the transfer policy, were also arbitrary. As the petitioner has discharged her burden and the onus is shifted on the respondent number 1 to show that the petitioner's transfer order was fair and reasonable in the facts and circumstances of the case. But the respondent number 1 has utterly failed to discharge its burden. On the contrary, the admission made before the Judges Inquiry Committee by the then Judge on the Transfer Committee clearly show that the transfer was made solely on the basis of the complaint made by the then District and Session Judge without verifying the veracity thereof. Not only that, but it is evident that the then Judge had not looked into the annexures attached with the representation, which included the free receipts etc. of the petitioner's daughter. Further, the respondent number 1 has failed to take into consideration the factors which were required to be considered while deciding the representation of the petitioner and had taken into consideration the factors which were not relevant. The then Judge of the Transfer Committee had clearly admitted that he had not gone into the annexures which were attached with the representation of the petitioner. Non-consideration of the relevant material and consideration of the extraneous material would come into the realm of the irrationality. An action which is arbitrary, irrational and unreasonable would be hit by Article 14 of the Constitution of India. This court therefore finds that the rejection of the representation of the petitioner would also not stand the scrutiny of law. The petitioner was a judicial officer and a mother too. The judicial officer in her must have been battling with the mother in her. On one hand was her career as a judicial officer, on the other hand was the possibility of her daughter's educational prospects and career coming into jeopardy if she shifted to the place of posting at Sindhi. A possibility of her mind engrossed with the feeling that she was subjected to injustice by the very institution of judiciary cannot be ruled away. Denial of her legitimate expectation could have led to desperation, exasperation and frustration. The frustration of the petitioner is evident from the language used by her in her resignation letter. It appears that in a gruesome battle between a mother and a judicial officer, the judicial officer lost the battle to the mother. The breakneck speed at which the events have taken place in the present matter gives rise to a suspicion that there is something more than which meets the eye. It will not be out of place to mention that in some high courts a practice is followed that whenever a judicial officer having good track record tenders his or her resignation, an attempt is made by the senior judges of the High Court to counsel and persuade him or her to withdraw the resignation. It will be in the interest of the judiciary that such a practice is followed by all the high courts. In the peculiar facts and circumstances of the case, the petitioner's resignation could not be construed to be voluntary. The circumstances enumerated would clearly reveal that they were such that out of frustration the petitioner was left with no other alternative. Therefore, the order passed by the respondent number 2, thereby accepting the resignation of the petitioner, is quashed and set aside. The respondents are directed to reinstate the petitioner forthwith as an additional district and sessions judge. Though the petitioner would not be entitled to back wages, she would be entitled for continuity in service with all consequential benefits. Coming to the next important judgment titled Sree Surya Developers and Promoters versus N. Sailesh, Prasad and others, pronounced on 9th February 2022. In this judgment, the Supreme Court has held that a separate suit challenging a consent decree is not maintainable. The facts of the case would be that the suit scheduled property was gifted to the respondent number 1, the original plaintiff, during his minority by his paternal grandmother, the respondent number 2, with a registered gift deed which was revoked with a revocation of gift deed. Thereafter, a registered development agreement cum general power of attorney executed between grandmother and the appellant, the original defendant number 2. The father of the respondent number 1 filed a suit as the next friend of then minor respondent number 1 for declaration that revocation of gift deed as being illegal and not binding on the plaintiff, and also for perpetual injunction. Subsequently, a compromise was arrived at between the parties. Thereafter, the compromise decree passed in terms of the memorandum of compromise. On attaining the age of majority, the respondent number 1 filed the present suit through his general power of attorney, praying declaration of right, title and interest over the scheduled property and declaration of compromise decree. He also prayed the revocation of deed as null and void. The trial court rejected the plaint on ground that in view of Order 13, Rule 3A of CPC, no independent suit would be maintainable against the compromise decree. On appeal, the High Court quashed and set aside the order passed by the trial court and remanded the matter to the trial court. Being aggrieved, the original defendant number 2 and 4, the developer and its assignee, preferred the present appeals with allegation that the High Court committed a grave error in quashing and setting aside the order passed by the trial court. The Supreme Court has held that the plain reading of Order 23, Rule 3A of CPC would show that no suit shall lie to set aside a decree on the ground that the compromise on which the decree is based was not lawful. The trial court was justified in rejecting the plaint on the ground that the suit for the relief sought challenging the compromise decree would not be maintainable. So far as the submission on behalf of the plaintiff that in the suit the plaintiff has not specifically prayed for setting aside the compromise decree, and what is prayed is to declare that the compromise decree is not binding on him, and that for the other relief sought the suit would not be barred and still the suit would be maintainable is concerned, the aforesaid cannot be accepted. A mere clever drafting would not permit the plaintiff to make the suit maintainable, which otherwise would not be maintainable and or barred by law. If the reliefs of declaration of title, recovery of possession, cancellation of revocation of gift deed, declaration for DGPA and deed of assignment cum DGPA are considered, the said reliefs can be granted only if the compromise decree passed is set aside. Therefore, by asking such multiple reliefs, the plaintiff, by clever drafting, wants to get his suit maintainable, which otherwise would not be maintainable, questioning the compromise decree. All the aforesaid reliefs were subject matter of earlier suits and thereafter also subject matter of the suit in which the compromise decree has been passed. Therefore, it is rightly held by the trial court that the suit in the present form and for the relief sought would be barred under Order 23, Rule 3A of CPC, and therefore the trial court rightly rejected the plaint in exercise of powers under Order 7, Rule 11D of the CPC. The High Court has erred in setting aside the said order by entering into the merits of the validity of the compromise degree on the ground that the same was hit by Order 32 Rule 7 of CPC, which was not permissible at this stage of deciding the application under Order 7 Rule 11 of CPC, and the only issue which was required to be considered by the High Court was whether the suit challenging the compromise degree would be maintainable or not. Further, as such, the respondent number 1 has already moved an appropriate application before the concerned court, which passed the decree setting aside the compromise degree by submitting an application under Order 23 Rule 3A of CPC. Therefore, the said application will have to be decided and disposed of in accordance with law, in which all the defenses, contentions which may have been available to the respective parties on the validity of the compromise decree would have to be gone into by the concerned court in accordance with law and on its own merits. However, it is observed that this court has not expressed anything on merits on validity of the compromise degree, and the same shall have to be decided and considered by the court which passed the decree in an application under Order 23 Rule 3A of CPC, which has been filed by the original plaintiff, and the said application be decided and disposed of by the concerned court in accordance with law and on its own merits, and the contentions, defenses which may be available to the respective parties on the validity of compromise degree are kept open to be considered by the concerned court in accordance with law and on its own merits. Now we are going to deal with the important judgment titled Papu versus State of Uttar Pradesh and pronounced on 9th February 2022. In this judgment, the Supreme Court has held that abhorrent nature of crime alone cannot be the decisive factor for awarding death sentence. The facts of the case would be that the appellant was accused of enticing a 7-year-old girl to accompany him on the pretext of picking lychee fruits, having thereafter committed rape upon the child, and having caused her death, and having dumped the dead body near a bridge on the river bank after having dragged the dead body over a distance of 1.25 kilometers. After trial, the trial court convicted appellant under section 376, 302, 201 of IPC and sections 5 and 6 of the Protection of Children from Sexual Offences Act 2012, and awarded death sentence to the appellant, and the same was confirmed on appeal. Being aggrieved, the accused filed the present appeals with allegation that the trial court and high court have not examined the mitigating circumstances existing in this matter, including that it is a case of weak chain of circumstances. It is contended on behalf of the respondent that concurrent findings on the guilt of the appellant based on proper appreciation of facts call for no interference. It is also submitted that the abhorrent nature of the crime justifies the death sentence in the present case. The issues posed for consideration are whether the conviction of the appellant calls for any interference, and second, if the conviction of the appellant is maintained, as to whether the sentence of death awarded to the appellant deserves to be maintained or deserves to be substituted by any other sentence. The Supreme Court has held that as against any judgment, final order or sentence in a criminal proceeding of the High Court, regular appeals to this court are envisaged in relation to the eventualities specified in Article 134 of the Constitution of India and Section 2 of the Act of 1970. It is not a matter of regular appeal. This court would not interfere with the concurrent findings of fact based on pure appreciation of evidence, nor it is the scope of these appeals that this court would enter into reappreciation of evidence so as to take a view different than that taken by trial court and approved by the High Court. The trial court and the high court have concurrently recorded the findings that the prosecution has been able to successfully establish the chain of circumstances leading to unmistakable conclusion that the appellant is guilty of the offences of rape and murder of the victim child, as also of concealing her dead body. It is also but clear that the foundational facts of the offences alleged against the appellant have been established. In the given set of circumstances, it could safely be said that the presumption contemplated by Section 29 of POCSO came into operation, and the burden came staying with the appellant, and it was for him to rebut the presumption and to prove that he had not committed the offence. The appellant failed to discharge this burden. Thus, even after examining the principal contentions urged against the concurrent findings written by the trial court and the high court, this court does not find any case of perversity or manifest illegality for which any interference in such concurrent findings would be called for. In an overall view of the matter, it is proved beyond doubt that the hapless child met with her gruesome end after having been treated inhumanly and having been subjected to sexual assaults, that the victim was lastly seen in the company of the appellant when he enticed and took her along to pluck and eat lychee fruits while shooing away the other children playing with her, that the dead body of the victim child was recovered at the instance of the appellant, and that the appellant failed to satisfactorily explain his whereabouts and his knowledge of the location of dead body. The medical and other scientific evidence has been consistent with the prosecution case, and then the defense version of enmity due to land dispute turns out to be false. The appellant was rightly convicted by the trial court, and his conviction has rightly been maintained by the high court. Both the trial court and the high court have taken the abhorrent nature of crime alone to be decisive factor for awarding death sentence in the present case. But the impugned sentencing order of the trial court does not indicate if the appellant was extended reasonable opportunity to make out a case of mitigating circumstances by bringing relevant material on record. The sentencing order also fails to satisfy if the trial court consciously pondered over the mitigating factors before finding it to be a rarest of rare case. The impugned orders awarding and confirming death sentence could only be said to be of assumptive conclusions, where it has been assumed that death sentence has to be awarded because of the grisly crime and its abhorrent nature. So the approach of the trial court and the high court in this matter while awarding sentence could only be disapproved, and this court does so in no uncertain terms. When the appellant is not shown to be a person having criminal antecedents and is not a hardened criminal, it cannot be said that there is no probability of him being reformed and rehabilitated. His unblemished jail contact and having a family of wife, children, and aged father would also indicate towards the probability of his reformation. The strong mitigating factor of probability of reformation and rehabilitation, particularly with reference to the antecedents and background of the appellant, coupled with his satisfactory jail contact, make out a case for communing death sentence into that of life imprisonment.